All right, hi everybody. Welcome back, Attorney Steve Vondran. Welcome to another exciting episode of Litigation Whiteboard. All right, I had a special request for discovery, meet and confer. Okay, so you get into the heart of your case. You start sending out requests for production of documents. You're asking the other side to supply certain documents that may be relevant to the case. You're sending out what we call interrogatories, which are basically nothing more than questions. And you get back what we call the SANDBAG. Okay, you get them back and you look at them. You go, they didn't provide any answers, or they were skirting around the questions, or they didn't provide the most relevant documents. This happens all the time. It happens so much that I'm starting to think that it's just a kind of a game that everybody plays. Anyway, but without further ado, let's head to Attorney Steve Litigation Whiteboard. Okay, so what do you do? So what do you do when you get caught up in this sandbag and the other side is just not giving you what you need to prove your case, or to prove, if you're the defendant, to prove your claims and defenses? Well, what you do is you basically set up a meet and confer call. It all starts with this. You have your discovery that you sent out. Typically, they're going to have 30 days to respond with a verification, which is under oath, saying this is it, I did a reasonable due diligence, these are the documents, here's the answers. That would be great in a perfect world, but what you typically end up getting is an inadequate response or evasive. And when that happens, you have to put together what we call a meet and confer letter. Now, it's never really fun, but it's part of the process. And this is general legal information only, not legal advice. It could differ in your local region. I'm from California, so we're talking about under the California laws, you're going to be putting together a meet and confer letter. That is going to describe the question that you asked, their deficient response, and what you want and why they need to supply it. Sometimes you're going to supply case law, saying you can't do this, you can't evade for that, you can't use this objection, those kinds of things. So you're going to put together a meet and confer letter, and typically under, like for example, under California state law, you're going to have 45 days to bring this motion to compel, what we call over here the motion to compel, saying, Judge, they will not provide the evidence that I requested, the answers, the documents, the things I requested. We had a meet and confer letter that I sent to them. They did not amend their answers. They could amend them and they could say, okay, you make some good points. I didn't understand the definition, or I'm going to add some certain, I'm going to amend my answer to you. My responses, I'm going to amend those. And you can just cure it without the motion. Judges don't always like these motions. They want you to figure it out, work it out between the parties. Then this is why you could face sanctions if you're not providing the proper documentation, the required responses, okay? So basically you're going to get the response, check your local rules, there may be special rules, check your judge's standing order, and there may be a scheduling order where you've agreed per stipulation to when these motions of compel may be filed. So always make sure you're checking to make sure you're not blowing a deadline or waiving your rights, those kinds of things, okay? But you're going to have the meet and confer letter pointing out the deficiencies. They're going to have a chance to amend. And then if not, you're going to do the motion to compel. And again, the motion to compel is going to have your question, their response, and usually courts will require a statement of each party. Now, in California federal court, we're looking at Federal Rules of Civil Procedure Rule 37. No timeline there, but again, check, because you never know. There could be a standing order that says there is a time frame. So you don't want to get lost in that. But yeah, California under federal court has an extra requirement. Now I'm talking Central District, Orange County, San Bernardino areas, things like that. But they have a special requirement. If both parties are located in the same county, they have to go meet each other. They have to actually go meet at each other's office, hop in the car, drive through the traffic and get there. This is, I think, brilliant. It's a way to stop the parties from sandbagging each other. But again, don't count on this to always work. But check your rules, see what it is. But it's really simple. It's you ask your questions. They're supposed to give you detailed sworn responses. If not, you're going to send the meet and confer letter. You're going to set up the phone call, and then you're going to have a call with them. And usually that meet and confer call, you're just going over all your questions that you deserve better answers to, kind of seeing if you can agree on things, maybe switch up a definition, maybe limit your question a little bit to help out. But they will, if you can give them a chance to amend and work it out amicably, that's always best. If not, you have the motion to compel, where you can seek sanctions, monetary penalties against the attorney or their party or both. So that's very important. But anyway, this is a general legal overview. That's kind of the process, how it works. It's not always the funnest part of litigation because, like, for example, you might just want to use the deposition. Where you get to the deposition, you can require them to bring documents. But it's nice to go into the deposition with the documents in hand. That way it can be more productive. You get a limited amount of time to do your deposition. But do what you can with the meet and confer process and stick with it. And you might just find you get some good nuggets, but the deposition's great. And if you do end up doing the motion to compel, typically courts want to know that you actually met and conferred, so you can put that in there. We met and conferred on this date and DDD, and try to avoid the motion. So that's meet and confer, guys. That's discovery disputes. This is very typical. It happens in almost every case I've ever litigated. There's some element of this. But I hope that's helpful. I hope you learned a little something new today. I appreciate you guys all watching. Don't forget to subscribe and hit that notification bell for more great videos when they're coming. If you need help, civil litigation, entertainment, IP law, internet law, you know where to find us on the web at attorneysteve.com. That's attorneysteve.com, the first name in legal services. I got to run. Have a great weekend. We're going to be back next week with I got some great videos lined up. Don't miss it. Bye now.